Welcome back to Brazil Crypto Report. Today I'm joined by Alessandro Rossi Martins, an attorney at Machado Meyer, to talk about the Brazilian Central Bank's new public consultation on crypto asset regulation. All right, so we had some big news drop late Thursday evening with the central bank releasing its long-awaited public consultation on crypto asset regulation. So today I'm joined by Alessandro Rossi Martins, who's a lawyer at Machado Meyer, who's going to help us understand what's happening with this. Alessandro, it's so great to have you on the show.
Thank you. Thank you for having me, Aaron. It's great to be here, and let's talk crypto.
Amazing. So just to get started, why don't you give yourself a quick introduction and talk a bit about your work as it relates to crypto and fintech?
Sure. So I'm a partner at Machado Meyer. I'm in charge of our fintech practice. And I've been playing with crypto since the word was like a bad name in law firms and no one wanted to talk about it. So I remember the first time, like 14 years ago or something, that I joined the partner's office and said, hey, I want to talk about Bitcoin. We should look into it. I said, we don't talk about this. And then like 14 years down the road, every single lawyer wants to be a crypto lawyer.
Well, let's dive into this. But like before we dive into some of the specifics, let's do a quick kind of rewind. And could you give us maybe a quick kind of recap of just how we got to this point? Because I know there's enabling legislation that was passed. The bank was officially appointed the regulator. And then we've been waiting for this consultation for a few months now. And then it just finally dropped on us. But maybe you should kind of give us a quick summary of how we got here.
Okay, so there was a bill of law that was introduced back in 2015, and that stated that crypto was a currency. And that was a bill that didn't make sense. And the market went to the Congress, Brazilian Congress, and started helping Congress come up with a law that would actually be applicable to the crypto market. And taking from the example of our e-payments law, that is very principiological and gives to the regulator the free range to regulate as it fits and to change the regulation in a quick way to adapt to market. So this law, after many years of discussions and back and forth, it was enacted in 2022, actually December last year. And the law didn't appoint the central bank in the first time as the regulator. It said there will be someone appointed by the executive power who is going to be the regulator for crypto. Then a few months down the road, after actually the market asking for the central bank to be the regulator, given its approach towards fintech over the last few years, which enables innovation, doesn't prohibit things without understanding, and has a very pro-market approach, in June, central bank was appointed as the regulator. So from then, people were expecting that the regulation would come to be published for public comments in August. It took longer, and now we understand why when you read the current document. And central bank just this week, like yesterday, published not a draft of the regulation, how they did in the past, but they actually published questions to understand how the market sees potential regulation and potential issues. And only after having this initial feedback, that they will draft the regulation or finalize the drafts that, we know they already have some like general drafts. We heard of it many times from representatives of the central bank, and then come up with the actual regulation. So I think the main point here is a change of approach. Instead of like coming up with a draft and saying people comment, they're just asking the questions, trying to understand further how the market works, and then they will come back with a draft regulation.
Got it. So this is a novelty in a sense. This isn't how they normally operate. They normally will just release the regulation, be like, this is what we got, or we'll ask for your feedback for these regulations. But here it's just a list of questions that they're putting out that they're asking for input on from the market, basically. Is that
yes?
Am I getting that right?
And I would say it's kind of the third level of the evolution. So first we would just get the rules, and they would be published, and they would be already effective. Then we got to the second step, was they publish the draft of the rules and say, give me your comments, tell me what you think about it, see if this works. If it doesn't work, let's talk about the draft of the regulation. It was already like a built rule. And now it's the third step of the evolution, where they're just asking questions and hearing from the market even before the draft regulation is out there. So it's a very inclusive approach and something new, and that's being very well seen by everyone in the market since yesterday.
Great. And then I assume you and your team were probably up all night studying this and dissecting it. So I would love to get some, thank you for coming on here to talk about it for one, but I would love to get your, after spending some time digesting this, like what are your big takeaways? What's interesting? What's novel here? What's important?
Okay, so I think the regulation, the questions, they are divided in 8 topics. So the first topic that they deal with is, segregation of the assets and risk management. So there's been a discussion during the Bill of Law that the law would establish that the Bitcoin or the crypto in custody with any service provider would be considered a segregated assets, which means that the same thing that whenever you put money into an e-payments institution, like a payment institution that issues e-currency, the real that you deposit with this institution is considered segregated assets, which means that this money, these real funds, they are not subject to any adjudication, or if the company goes bust, it cannot be used to pay employees, to pay taxes, to pay any other obligations of the company. It's segregated and belongs to the individuals that have the account. So there's been a long-standing discussion about whether we should do the same thing for Bitcoin and other crypto assets that are deposited with the exchanges or any custody service providers. And the final Bill of Law, it deleted and it excluded all the provisions that dealt specifically with this matter, because it's a very political issue. There are market participants that are against, others are in favor, and there has been a big discussion. So the law, we needed the law. So the law passed in 2022 without these provisions, but central bank took upon themselves to tackle it. So the first question is, they try to explain why segregated assets would be an option, but they don't assume that's going to be the only option. And that's the interesting part, because since the segregation of assets already works for the central bank in the e-payments law, the expectation was, okay, that's the automatic answer. That's the way they're going to go for it. But when you read through the questions, they're considering many other scenarios, from an open scenario, anything that people can suggest, from talking about creating the equivalent to an FDIC in the US, which is called, what we call in Brazil, an FGC. It's the kind of a fund that guarantees up to a threshold deposits of the individual. So it's pretty much the same thing that FDIC does in the US, but creating such an entity for the crypto market. They're also asking the market participants which other existing features from the incumbents market, for example, that banks use, that we could adapt to the crypto market and have as a way to manage risks and tackle issues relating to custody, and guarantee that whatever crypto you have deposited with an exchange or any service provider is actually going to be there when you go and you want to get your crypto back. So it's the first subject that's being discussed. It's the biggest range of the public consultation. So it's the one that they have more questions and more discussions. And we already heard some comments about, okay, let's talk about Basel rules, because banks, when you put a deposit, they have to have like minimum capital requirements, and they segregate a part of those deposits for compliance with Basel rules. So can we do this? Would that make sense for a crypto market? Another discussion that central banks is bringing here is the practice of staking, which is something that we would expect a full prohibition. But in the questions, they're saying, we're not saying we're going to prohibit it. If we decide to allow this kind of practice, how should we go about it? How can you make it safe? How can you make sure that risk is going to be managed properly, so you don't impose a systemic risk to not only the financial system, but let's say the crypto system now. So I think this is the big innovation from the public consultation is this first batch of rules regarding management of risk, segregated assets, and custody. So we have a lot of other minor, let's say, topics, like how they're going to go about the grandfathering regime. So companies that are already operating, how hard it is for such companies to adapt to a new regulation. How long do you think it's going to need? What are the big challenges? They're asking the market. So when they come up with this grandfathering regime and how long that's going to take, they want to understand what are the big challenges to make sure that they don't create something that's way too broad and it's going to take like 5 years, for example, for the market to be fully regulated, but not something that's going to be like 6 months, which is the minimum according to law. That's not going to be enough for the market to regulate. And it's kind of the same approach they took towards the payments law. The payments law had a grandfathering provision and the regulation. And when they realized it was not enough time, it was postponed a few times so that people would actually be able to continue operating and it doesn't kill the market. It actually helps it grows. Another very interesting topic that they bring here is what are the roles of the incumbents? So should financial institutions and payment institutions be authorized to operate in the crypto landscape? Should they need a separate license? Can they add the license to their own license, or should those licenses be separated? Can we have a bank also getting a license to also operate with crypto assets? Or should the bank conglomerate have to incorporate a separate entity to operate and get a separate license to operate in the crypto landscape? So these are all questions they are asking, and that's very interesting too, because a few months ago, the main take was that financial institutions and traditional institutions would not be able to operate in the crypto landscape in the same entity. So this discussion about adding a VASP, that we say that's a virtual asset service provider license in a financial institution, was out of the question. That was the full expectation. When you read the questions, it's not out of the table. They're actually asking, does it make sense? What risks this is going to pose? What are the concerns? What are the advantages of having everything in the same entity? And can we have the same kind of controls? Do we need extra controls? And what extra controls would mean for these players? Would it prohibit them from a de facto perspective, from a practical perspective, from actually operating in this landscape? Because that's not the goal. The goal is to have everyone being able to compete equally in this landscape. So how can we make this sure, but also making sure that the system is protected, which is their primary role, is making sure that financial system is protected enough and is not exposed to significant risk. That's a new thing that's very interesting too in the rule. I think there's one more topic that I would like to touch upon when they're talking about hiring essential services. So back in 2017, I guess, when they created the rule on cybersecurity, central bank got a provision that says you can only hire cloud or any cybersecurity services of companies based in Brazil. And that was a big problem. We were at the beginning of the use of cloud services to store data. So banks and financial institutions had their big data centers that were actually physically located here. But at the same time, you got all the fintech and all the new companies coming into the financial system and saying, we're going to use Google, we're going to use Microsoft, we're going to use any other service providers to store our data. And if you're saying that I can only hire a company that's based in Brazil, I cannot use these major service providers to store data. And that was a question that was, okay, these are the major ones. They're the ones that are supposed to be more secure. And you're saying that I can only hire the small one that is being incorporated right now in Brazil. Or we already had a few big ones, but like in comparison in the like grand scheme of things in the world, it's not a fair comparison. And that was something that the central bank was very worried about, being able to, send an official letter and get information when needed if you're talking about and hiring entities that are headquartered anywhere. A few years after, they changed the rule and excluded this provision, saying that these service providers can be anywhere provided that they follow X, Y, and Z rules. And the agreements observe X, Y, and Z minimum requirements. And when we're talking about essential services here, they're kind of taking the same approach, trying to understand what kind of services do you need, who you need to be here, who you need to be abroad, what kind of other services apart from the obvious ones like custody and know your client. And I think usually the obvious ones are know your client, service providers, and custody. What are the things you need, and does it make sense to allow them to be abroad? And one of the specific questions they get into, when you get into custody service providers, does it make sense to let the custody being held abroad? And what are the effects of it when I need to go into the judicial system and have an execution or have any kind of adjudication, any kind of judicial procedure to actually find those assets? This is a very interesting approach, and you see the evolution of how the regulator looked at things they did in the past that created a problem at a moment that they're not, let's say, ready to open to service providers abroad, and now they're being very careful to try to understand: can I do this? Should I first, and can I limit it to companies that are based in Brazil? Is this the best for the market? Is it the most secure? Or having it open, what are the consequences? Because we know most of the companies already use service providers abroad. Why they do it? I think that's the main question. Why do you go for a service provider that's not here? Explain to me. And goes again about, what I say is that for this regulation, everything's possible. They're open to hear, opinions on every single important matter that is under discussion up to this moment.
That's super interesting, and thank you for that. That's a lot of information that you've managed to synthesize over the course of the night and the madrugada, right? So thank you for that. That's super helpful, and it's super interesting, and it kind of goes back to that old principle of you can't get the right answers if you don't ask the right questions, right? So I think they're in this mode of acknowledging that hey, we don't have all the answers here. We're not necessarily the smartest people in the room when it comes to this stuff. We really need to ask the right questions of the industry. To get the information and the answers that are most helpful here. So it sounds like they're taking a very productive approach here. So, and that it does help explain why this process has been kind of delayed for so long. I know people have been waiting for this for several months now. But it's look good. They've been taking their time. They're trying to get
That's
the questions
the kind
right.
of delay we like.
Yeah,
we like this kind of delay. We appreciate it.
Exactly. And then so. I guess one question here about just, I know there was on Monday of this week, I believe it would have been on the 11th, the central bank did a live webinar where talked for about 45 minutes or so outlining some of the principles and some of their goals and things. And they touched on some of these themes of, asset segregation and kind of treatment of foreign brokers and things of that nature. And it does sort of feel like they are trying to steer, they're trying to how to regulate the foreign brokers is this kind of thorn in their side that they can't really figure out. And just would like your initial thoughts on how, just based on your reading of this consultation, how are they kind of treating this issue? How are they approaching this question based on the information we've received this week?
So it's a tricky question, and it's a tricky question not for me. It's a tricky question for the regulator, because when you're talking about services that are provided online, it's very hard for you to say you cannot do it. So you cannot go online and find a website or use a VPN, because that's what people do nowadays, find a service provider and hire these services. The problem is we have a legal problem here, is what can central bank regulate? So what is the extent of their power to regulate and supervise the market? And when you talk about foreign service providers in general, even they are servicing Brazilian customers, they will be covered by consumer law. But general rule, it's very complicated for secondary rules to be applied to the service providers, unless you have something in the law that specifically deals with that. So usually what they require, and that's how the financial system works, is that you have to set up a company in Brazil to provide X, Y, and Z services. And I'm not saying that's the approach the regulator is going to take here. I'm saying historically, that's how it works. For you to provide this kind of service, you have to set up a company, a subsidiary in Brazil, and that subsidiary will have to be licensed. Whenever you're offering that services, that's how we regulate. That offering of those services can only be done by licensed entities, and that's how it goes for financial institutions and payment institutions. The offering of financial services is private of financial institutions. The offering of payment services is private of payment institutions. But we're talking about rules that were built. The payments law is from 13 years ago, from 2013, from 20 years ago, sorry. And the financial institutions law dates back from the 60s. So we are not in the same world anymore, and that's the challenge. How can I make sure that competition and these foreign players come to Brazil and offer services and improve the level of service to Brazilian customers? But at the same time, how do I make sure that minimum rules protecting customers, dealing with anti-money laundering, sanctions, and also kind of a level playing field, because local players, they will have to be licensed and they will have a regulatory cost. How can I make sure that people that are coming abroad and offering the services directly to Brazilians, for example, and are not regulated, they're observing the same standards, and they're not taking advantage of the fact that they're not regulated? So there are many questions that are involved in this. And here in the public consultation, they kind of touch some points on how custody being held abroad, some other services being held abroad, but they do not ask these specific questions, which is very interesting, because at the end of the day, this is more of a legal question and a decision on how they want to regulate and how the principles of the law, which among other things are protection of consumer, making sure that anti-money laundering law is observed, that crimes are not committed, and that competition is observed, they are guaranteed, because that's the role of the regulator. They have to abide by the principles set forth in the law. So I see this discussion about foreign service providers that are not planning to be based in Brazil as more of a legal discussion, and there's little room to operate with that, than more of how we are going to regulate.
Got
I
it.
think
Got it.
that's the tricky part, because they don't want to prohibit it. No one wants things to be prohibited. That's not the approach of this central bank. Central bank is, okay, I understand how I make it work, but this is a question that's not so easy to adapt and make it work. So I don't think the public consultation will give us much hints about this specific topic. That's something that will come from their legal department and discussions, and lawyers helping with this and coming up with a solution much more based on what the law allows them to do as like a regulator, and what's the delegation of powers that they have, as opposed to just coming up with some rule that will change things. There's a limit, like it's kind of the non-delegation theory in the US. There's a limit to what the regulator can do, and he cannot supersede these limitations that the law has established for their operation, for their regulations.
Got it. Got it. So just moving ahead here, or looking ahead to the next 6-12 months. So we'll have, it looks like the submissions or the comment period is open until the end of January for folks to submit answers to all these questions. And then sort of like what happens after that? I guess what does the process look like?
First, we're gonna have a very busy holiday season and summer here, but I'm not complaining. That's exactly what we like. But apart from that, what they usually do, and the expectation is that they're receive all the comments. The comments are usually public, so everyone can read everyone else's comments. They are submitted to a public system, and it's going to be available in the central bank website. And after that, they will kind of digest. Usually, it happens like some events or some meetings, inviting people to come and explain what they mean in some of those comments. Really, this kind of digesting of what people are asking and saying. And I expect that, I would say by the mid of next year, we are going to have the draft regulations. For this level of questions and so many questions, I wouldn't bet we would have the draft regulation before mid next year. And it's not, even reasonable for us to expect. If you want this level of regulation and this level of understanding in the market, which is a good thing, we need to understand that it takes time. And it's only fair.
And then so it looks like the timeline is that they're going to release like a second consultation in like April or May-ish as well. They're going to basically take all these questions, aggregate everything, come up with a draft, and then put that draft back out for public comment again.
That's my need next year, next step. It's this.
Okay. Yeah. So you think that's going to come out? Okay, and then so that will be put forth for public comment as well, and then the official, like kind of fully codified official version would come out maybe like around this time next year, maybe.
I would say around September. This second step is usually faster, because usually the regulator is going to hear the market about wording and some comments. But if you look back at the fintech rule, after the public consultation and all the comments, it took about 2 or 3 months for the final rule to be published. So when you look at the open banking, it was more or less this timeline too. I think PIX, I don't recall exactly, but it wasn't like too long either. So the second step is they already have the draft regulation. They usually have their mindset on a lot of the main points. They just want to hear about wording, things that the way they write somehow may, be interpreted in X, Y, and Z ways. So they hear everyone and kind of make some minor adjustments to the rule and then publish the final rule. And then we should have like the grandfathering structure. So it doesn't mean that the rule is going to be applicable right away to everyone. So we expect that there will be an adapting period for people that are already operating or people that will start operating after it. So
got it.
And that's a tricky thing for people that want to set up their business in Brazil. Usually the grandfathering rule, it works in a way that it applies differently for companies that are already operating as opposed to those that are going to start their operation so they don't have any kind of business yet. And the grandfathering, it benefits differently those different entities. That's how it happened in the past for other services. So there's we've been seeing this for a while, this kind of rush of like companies wanting to start operating as soon as possible with this fear that if they don't, they will not benefit from the grandfathering rule. So one thing that's helpful is like reading what is in this question, reading the comments, and then having like the actual draft rules will help people prepare and make sure that they will benefit from, to the extent possible, of course, to the grandfathering rule once it, is effectively enacted. That's the one thing that we should keep our eyes on for anyone that's planning to, come to market to Brazil for the next 2-3 years. I would say keep an eye on the grandfathering regime for this rule.
Got it. Okay, yeah, that's super helpful and super important context. I guess just to wrap up here, one last question: who are the people that should be filling out these, or that should be submitting comments here, answering these questions? I was just on the site this morning, just looking at some of there's already 10 or 12 comments already in there, so people are obviously excited about this. Yeah. And there's somebody's it's don't ban Bitcoin. Another person's better because they charge lower fees. It was just kind of random stuff, right? But I mean, who are the people that? I mean, obviously, they're trying to. It's a public consultation, so it's open to everybody, right? But
no.
I guess who are the people that the central bank wants to hear from? I guess how would you describe that?
They want to hear to everyone that will be in business in this market, that will be affected by it. So they want meaningful, insightful comments, based on precedent and study and actual practices. So the main companies or any company that is in this business or planning to be in this business, it's not open only to Brazilians. So foreign companies planning on coming to Brazil and setting up businesses in the crypto landscape, they can send comments as well. The tricky part is that comments has to be in Portuguese. So we do this sometimes. We help companies draft out everything in English, help them understand, and then we just translate it and submit it. So anyone, and not only the crypto entities, but also the incumbents. So they want to hear the banks. They want to hear, because, one of the discussions is if you're a bank and you want to do crypto, and we saw that Itaú just launched that tokenization platform last week. So the incumbents, they are looking at it too. So how are you going to go about you? What do you want me to do? How would that work? What are your plans in terms of, entering this market? Because the other question is, if you are the incumbent and you don't plan on entering this market, I'm not going to waste time doing this. That's a discussion that central banks usually say. I want to spend my time in things that are going to be useful for the market. I'm not going to stay here 3 months discussing something that no one's interested in doing. So that's also where these questions go. But we fully expect that financial institutions will be operating with crypto. There is a lot of interest with that, a lot of interest from incumbents part, and they are the ones who also are going to submit comments. So anyone that is involved in this business that wants to set up a business in Brazil, let's say again, the next few years has already a plan, can participate and should participate to this public consultation.
Amazing. Well, Alessandro, thanks so much for your time this morning. How can folks get in touch if they want to learn more?
If they want to learn more, they can go to our website. It's machadomeyer.com.br. And just find my email or just find my LinkedIn. It's Alessandra Carolina Rossi Martins. I think these are the easiest ways to get in touch. And I'm happy to talk to anyone interested in talking crypto in Brazil.
Amazing. Well, thanks, Alessandro, so much for your time. And thanks, Evan, for listening. And we'll be tracking this subject closely in the coming months, as it's obviously a pretty big deal, much anticipated. So thanks so much, Alessandro, for coming on and helping us to better understand this.
Thank you, Aaron, for the invitation.